Good afternoon, and welcome to the top 7 strategies that increase case value and 5 mistakes that kill it. I'm Daniel Schumer, and I'm delighted to introduce today's speaker, Michael Alder. Michael Alder is the owner and senior trial attorney at Alder Law, a Los Angeles firm focusing on plaintiff side personal injury, business torts, and employment litigation. Known as one of California's top trial attorneys, he has built a reputation for significant settlements and verdicts across a wide range of cases. He's a past president of CALA, a published author on trial strategy, and a longtime supporter of the plaintiff's bar. Mr. Alder, we cannot wait to hear what you have to share with us today. The floor is yours.
All right. Hey, guys. I'm going to tell you first about the foundation of kind of how both sides think. And when you understand how each side's bread is buttered, then you can understand what, as a plaintiff, you need to provide to the defense, what the defense needs to get from the plaintiff, and to collaborate, and you wind up resolving cases for more money and faster. On every page is my cell number, my email, my social media, and on all of my social media channels, you can order my book, Trial Lawyer's Bible. And I have found, again, in my own practice, that the secret to success, more than anything else, is doing stuff that I don't feel like doing consistently. And usually that is just on the outside or the other side of my comfort zone. And so as we go through these strategies, we go through these activities, you will have obstacles that get in the way, that if you become able to get through the obstacles of, I don't have enough time, it's not really going to yield any results, it's going to settle anyway. If you make obstacles the way rather than in the way, you will make significant gains as a plaintiff's lawyer on the value of your cases. And as a defense lawyer, you will get kudos because you are doing the things that you need to tell your supervisor that you can settle this case, and you will get kudos. So I want to start with kind of a general misunderstanding that I see a lot of lawyers, newer lawyers, not younger, newer, misunderstand. They think that we are in an adversarial system, and that means that you hide the ball. Nothing could be further from the truth. And by the way, if anybody wants to raise a hand, ask a question, I have no problem stopping. At the end, we can have questions. I'm about to give you the elixir of success. And so I would expect y'all to have a lot of questions. Come on now. So this is an adversarial system, but it is a collaborative process if it's done the right way and the most effective way between the plaintiff and the defense. Now, what do I mean by that? If you could go to the next slide, right? You got to understand that trials don't happen very often. I tried 10 civil cases last year. The most I've ever done is 11 in a year. 10 is more than, it's a lot. But even with those 10, that was only a small fraction of the cases that I settled. And so we focus all the time on trials and, Mike, when are you going to try another case? I want to come see you close. And what I'm like, that happens once in a blue moon. How about we pay attention to taking depots? How about we pay attention to providing the other side with information they need to value the case? That's how you serve your clients. That's how you make money. But when I say case value is not one at trial, it is one starting when you get the case of providing information to the other side, sometimes without the other side asking. When they ask, providing them with a full accounting, not hiding the ball, not hiding the pre-existing injuries, etc. And I want to go through that. So next slide. I want to talk about some basic premises that govern how you should behave. Most plaintiff lawyers I hear, that they tell me, man, the defense are a bunch of jackasses that are just trying to screw us out of money, that they make money by paying us less. And that's not true. Now, I know that what I'm about to tell you is correct because I've done it for 32 years. I know it as well as because a managing attorney that I hired of my firm for several years ran Farmers In-House Counsel in California for 15, 20 years. And what I've learned and what I know is true, and for the defense lawyers in here that are listening, give me a hey now shout out if I'm telling the truth here, is that adjusters and in-house counsel get kudos for resolving cases within reserves. So if there is a reserve number, and what that is that the insurance company values a potential settlement of a claim by putting a reserve number on it. And they are incentivized to be relatively accurate because whatever above the reserve money they have, they can invest in the market and make money. And so the government requires the insurance company to value the potential claims and set that money aside. So you can see that when a case is resolved within reserves, right, then they get to release the rest of the money if there's any money left and then redo it. And that helps them free up money to go invest in the market, which is where they make most of their money. Now, you got to understand that reserves are set early, but can change over time. And the primary way that you get reserves set higher for the plaintiff is by giving them information as soon as you can, by showing that you are a good lawyer. Right? And so let me give you an example. If you've got a reserve that's set at $500,000 and the defense lawyer settles that case for $499,000, they get kudos. If the reserve is $400,000, same case, and they settle it for $499,000, they get fired. They don't get authority. The only difference in the case is what the reserve was set. So you got to pay attention as we're going through this, and I'll pull all this together, is that while you are providing the other side as a plaintiff with information that they need to value the case, the silver lining is how you do it can many times positively increase the reserve, and that case settles for more money, same case, more money, because of how you have provided the information. And so I want to talk about how you provide information in addition to what you provide that will make a material difference for a plaintiff in how you make money, that will benefit your clients dramatically. And if you're on the defense, how you can make yourself available to the plaintiff and maybe explain to some of the newer lawyers that you're not out to get them, you're out to be fair and reasonable. So I want to talk about this now as the next slide. Generally, the plaintiff wants money. The carrier, adjuster, defense has money. The carrier, adjuster, defense needs information to document their file, to justify to their supervisor and to that supervisor's supervisor on audit. And if it's a bigger case, that supervisor's supervisor's supervisor. And they cannot release money without having in the file certain information checked off. The plaintiff has the information. So right away, this adversarial system, if you look at it as collaboratively, the plaintiff is trying to get the defendant the information that the defendant wants and needs to check off to look good to their boss. And if they do, they have the money to give to the plaintiff. Why would you ever hide the ball? Why would you ever not try to be as helpful as possible to make sure that the defense has all of the records, has all of the medical bills, that understands the injury, that has all of the police report, the property damage photos? Why in the world, if there's a pre-existing injury, would you try to hide that? Because once they find that out, you've lost all credibility, right? They're not out to get you unless you do something that makes them rightfully out to get you, right? So let's go to the next slide with this idea of plaintiffs want money, defense needs information, defense has money, plaintiff has information. So if you're running your own firm as a plaintiff, for my practice, I don't really care how much money I have at the end of the year that my adjusted gross income is. I don't care. What I care is about, if I need money, do I have it? And that's called cash flow. Cash flow is when you need money, you have it. If I have $1 more than I ever need, I am unlimitedly wealthy. Now, my net worth may be $1, but if I always have $1 more than I ever need, I'm unlimitedly wealthy. So if you think about cash flow being important, and you think about the way to make money on cases and to get cases resolved is to get the other side the information that they need. And you know what they need. I'm about to go over it. And cash flow is really important. The faster I can do that, the faster I can use some of the techniques I'm going to talk about to short circuit the delays. If I can give the other side information I know they're going to need without them having to ask for it, if I don't have to wait for them to send me discovery and then wait 35 days and send it to them, if I can already know they want it and send it to them, if day 5 after discovery, I have the answers and I give it to them, and I've done that now 25 days earlier, and I can do that on all of my cases, and the time on desk in my office of a case goes from 18 months to 14 months, my firm is more valuable. I've made more money because my cash flow is going up. Same cases, same information, same everything. I'm just doing it a little faster. Okay, so let's talk first about the information that 85% of the plaintiff and the defense, if they have this information, can value a case. Let's go to the next slide. Okay, and before we talk about this, before I tell you the information that you and the other side need, I want to add one more thing. Anybody ever heard leopards don't change their spots? Daniel, you've heard that term, I'm sure. What does that mean? And here's the example I give. You know what? If I was a younger man and had not happily married with 6 kids, and I was dating and I was going on a blind date, and I show up late and I'm disheveled and I'm sweating, you know what that woman who's been waiting for me is thinking already? I'm a loser. I'm not husband material. I'm not reliable. Because we all know that statistically, leopards don't change their spots. And somebody who's late, who's rude, is usually a loser, is usually not a good, doesn't follow through, doesn't have a good job, etc. Now, I may have been late because I was helping a little old lady across the street. I may have a legitimate excuse, but we all have experienced that usually I'm unreliable and a loser and whatever. Statistically, leopards don't change their spots. And the best that I have ever seen of a group that can figure out what kind of leopard you are is insurance companies, because they have statistics with hundreds of thousands of claims. And they know that plaintiffs' lawyers that do X, Y, and Z statistically are likely to do A, B, and C. And conversely, lawyers that do this, this, and this are likely to do this, this, and this. And we'll talk about some examples, but let me just give you an example. You, as a plaintiff, have a case and you wait a year and 10 months and file right before the statute. You maybe say, well, my client was still treating, I have good reasons. I was, out of town and I would have, but statistically, you're probably full of crap. And the carriers don't care about the one-off good reason. They know after thousands, hundreds of thousands of claims that the leopard, the lawyer whose spot is, I'm going to wait and file right before the statute, statistically is not a lawyer that tries cases, spends money on cases, will likely settle the case for cheap to try to keep their fee rather than referring it out to a trial lawyer, will not follow up on discovery, likely doesn't take a lot of depositions, is an easy mark. And you've told that carrier all of that information by just how you behaved at the beginning of the case. Right? So I want to take that and show you the information that you should be providing that will help you get a case resolved. But the silver lining is that as you do that, and as you do it early in the case, and as you do it, you're telegraphing that you know what you're doing. You're telegraphing that you know they need the information. You're telegraphing that you're not afraid of your case. That carriers have figured out that lawyers who know what they need, who give them the information they need, that don't hide the ball, who move cases forward, are statistically the ones that will file if they get a BS offer, that will take depositions, that will file motions to compel, that will try cases, that will spend money on cases. All figured out because in pre-lit, I'm giving you all the information you need. They have figured that out. So the silver lining of providing the information in the way that I'm going to talk about also tells them what kind of leopard you are. And those are the, anybody ever wonder why I get the Alder bump, right? There's a bunch of us in LA. I go to mediation and everybody's here watching me. The mediator's like, well, they went off for X, but with the Alder bump. And I'm like, is that because I'm devilishly handsome and an excellent dancer? They're like, well, no. But they have figured out that if you don't settle the case, that you're going to go to trial, spend money, blah, 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 blah. And thus they're willing to give you top dollar because they've already figured out what kind of leopard you are. AKA, I tried 10 cases last year, right? They've already figured out that I tried cases. In addition, not just because they know I tried cases, but how I act at the beginning of a case. Okay, any questions on that so far? And then I'm going to go to the goods. This is good stuff. By the way, did I mention that my cell phone number is 310-710-3345, and all my information is here. Good Lord. Is there anybody who's got questions? Everybody in my office does. I know my question
We
is,
we
why don't
do
you
we do have
question?
one question. It's
Oh,
from Jean. It was
yeah,
in the beginning of the program. Who sets the reserve and how do they come to that number?
great. So the reserves are, they don't tell you exactly how they do it, But the reserves are usually set once there is enough information up front to at least get a general idea. That reserve can be amended once there's a lawsuit and depositions come. That reserve can be amended if there's a big ticket item, like a witness is deposed and they go, yeah, the defendant clearly was at fault, right? So you want to always do what you can to provide the information as early as possible so that that initial reserve analysis has as much information and will benefit. You know, it's harder to go to the top if you start at the bottom rather than the first reserve being in the middle. You can get to the top a lot easier. Good question. Okay, let's go to the next slide. So here are the things that we have a checklist. And if you guys, I don't know if I gave you my cell number. I may have told you about my social media. I'm not really sure. But if you reached out, I have this on a PDF that we have in our office that we print out and laminate. But here are the things that if you as a plaintiff's lawyer can start to provide to the defense as soon as you make a claim. Most important, what's the plaintiff look like and how do they present? Don't you want to know how old your plaintiff is? What kind of person they look like? Are they attractive, not, heavy, skinny, old, young, well-dressed, not well-dressed? So the first thing I do is when we get a case, I'm like, plaintiff, send me video and photo of you before and after the collision or the event. And we have a company that goes and mines their social media, not necessarily because I'm worried about what they're going to put on social media after the collision, but a lot of times plaintiffs just, I don't have any photos of me. And yes, they do. They have it all on their social media. And we get that. We get that and provide it to the defense. You don't have to ask for it. We're giving it to you. Property damage photos and estimates. Proof of insurance so you're not Prop 213. Well, they didn't ask for that. I'm like, get out of your head. You are trying to check off boxes and show them who you are. Send them the police report. Send them the property damage photos and the estimate. We answer form interrogatories pre-lit. Oh my God, Mike, did you realize you screwed up and answered form interrogatories pre-lit? Yes, Mr. Adjuster, were they helpful? Man, it was super helpful. Exactly. That is a leopard telling them, I know what you need and I'm giving it to you. Give all of the records so they can check off that they have all records. But don't expect an adjuster or an in-house counsel, maybe now with AI it's a little easier, to read 2,500 sheets of paper. They've got to tell their boss they got all the records, but maybe also send a separate file with the important records, the MRI report, in a PI case, MRI report, the surgery report, maybe the record of an epidural, something like that, so that the other side doesn't have to work when they go to get money and answer questions to their boss. What is the injury? You don't want them to have read 2,500 pieces of paper. They won't do it. They'll go to somebody else's case and settle that case, right? All the Howell bills, what's paid and what's not. If there's pre-existing injuries, we disclose it. If we have prior records, we give it to them. I have found routinely that any pre-existing injury that we disclose up front very rarely is a big deal. And I have a ton of viable arguments that, yeah, my client was injured before, but what this did was it took away the little bit of reserve they had. Shit, it's even worse that they had a pre-existing injury. If you don't disclose it and the defense finds it, it's a cataclysmic event. You're a liar, you're a cheater, etc. And if you want real money in a case, you want a defense to pay you $1 million or more, do you really think they're not going to look into the history of your client? And when I find that somebody who refers me a case and they've hidden past injuries, I'm like, take the case back. I don't even want to deal with your ass. You're telegraphing everything that is not me. And then we'll talk about this once litigation starts. But many times for bigger money, the supervisor on the other side has to also confirm that the plaintiff's depo was taken and that there was a defense medical exam. So as soon as we get into litigation, we notice the defendant's depo as soon as we can. That's within 20 days after service. But we also offer our plaintiff for deposition and medical exam immediately, and we waive the 35-day. Hey, if your doctor's free next week, let's do it. Because I understand on a lot of cases, once that happens, then the reserves can get finalized and they have everything they need. And if that happens 2 months after the lawsuit is filed, it settles in 2 months. If it happens a year and 2 months after the lawsuit is filed, it settles a year and 2 months from now. Same case, identical case. But now you get the money for your client a year earlier, and you probably get more because you're also telegraphing that you're a real lawyer who knows what they're doing, who is organized, who, if they're not going to pay that money, is going to go to trial and get more money. But all you're doing is the same amount of work. You're just doing it earlier. And you're doing it in a frame of mind of, how am I helping the other side answer the questions that their boss or their boss's boss is going to need to have answered before they open the checkbook? But Mike, I thought that the way to be a good trial lawyer is to be scary as hell. Say, up yours. I'm going to kick your ass. I'm not going to help you at all. I need you to pay me because you're terrified of me. No. No. You got to give the other side what they need. They can't do anything without that information. And I have found that I'm the most afraid of the defense lawyers that don't play games and understand that if they have information, they need to give to me so I can understand the case. I'm afraid of the defense lawyers that are open with me and say, Mike, this is what you don't have. And if you don't have it, I can't give you the money. If you do have it, I can. I'm like, that person knows what they're doing. And that leopard is likely a pretty good trial lawyer, probably a pretty reasonable person for a jury to understand. I'm way more afraid of that defense lawyer than the guy who's an asshole trying to shout me down in depo. I'm like, you're shouting in depo? I love it. I am going to kick your ass at trial because you do not understand the big picture here. Now, you're not scaring me by yelling at me. You scare me when you talk in a calm voice and you talk real shit. I mean, that's scary. And the same goes with plaintiffs. So let's go to the next. If anybody's got any questions, Daniel, maybe if you see them, you can, I can't really see them here, but.
We do have two questions. Number one is from Jean. I have a case where the city attorney wants a blanket access to my client's medical reports. Should I grant those? And if the client is hesitant to grant access to all his medical records, how do I get him to feel okay about sharing all his medical records?
All right. I don't know if anybody can see this on there, but let me just say, again, the question is, hey, I got a case. The city attorney wants authorizations for all my client's medical records. What if my client doesn't want to do that? So first of all, if you come from the same mindset, the other side needs, the city attorney needs that information to be able to check off to their supervisor, right? I see a lot of questions like, well, but this is a shoulder case. Why do they need the 10-year-old ankle? Those aren't relevant. And I'm going to fight that. Why would you do that? Why do you think that when the other side goes to their supervisor and the supervisor goes, do you have all the records? Do you really think they could say, well, I have all the records that the plaintiff's lawyer told me were relevant? If If they're not relevant, who cares if they have them? They need open disclosure to check it off. So my question or my answer to you is, we give open authorizations for any records other than mental or drug and alcohol. That's it. Right? And if there is a TBI or something more than an extra emotional case, then we will talk about giving mental health records. But in those cases, we want to see them first. Same with drug and alcohol. But again, if your client doesn't want to give medical authorizations for non-mental health and drug, you should be wondering why. And you should be questioning that. This is not trying to get one over, right? Your job is not to make a crappy case that is really crappy because the client's not telling the truth and somehow pull a fast one on the other side. No, doesn't need it. You represent real, legitimate, injured people. You have to show that injury, and you're much better off full disclosure and dealing with what you have than trying some hoodwink. And then before I move on, the last question I saw was, oh, which provider do you use to scour your client's own social media? It's called footprint.com. Jackie, I don't know if you remember what their first name is, but it's Footprint. For $200, they will go 5 years back on all of the social media platforms, and they will put it into a beautiful spreadsheet. And again, I do it on every one of my cases. It's a case cost. But I mean, obviously you're checking to see if post-collision they're posting anything. But far more valuable is you get years of social media videos and photos showing your client in the best light, showing them happy, showing them enjoying life at a concert. And if you usually talk to your clients, I find when I'm like, hey, do you have any good photos of you? They go, nope. And then you go on their social media and they got 1 million of them. So footprint.com, $200, 5 years back. It's dynamite. It's well worth it. Okay, let's keep moving. Oh, look, my social media is on the bottom, my phone number and email. Jeez, Mike, you make it so easy to just reach out or to follow you or go on and subscribe to your YouTube channel or order your book. Man, so easy. Okay, next. Strategies that increase value. Let's go to the next slide. All right. So I just talked about in every case, as soon as you can, plaintiffs start giving the defense this information. But for plaintiffs, I want to talk about some specific strategies that I see that when you do it, add value. When you don't, you're telegraphing, sometimes unintentionally, the wrong thing. If you make a policy limits demand, you have a case and the case is relatively worth the policy or more. If you make a policy limits demand by 998, by just a letter demand, and the defense doesn't pay it for any reason, whether they say rejected, whether they say it's premature and I don't have enough information, whether they offer some other number, within a day or two, you got to go above the policy. Now, why do I say that? Well, because probably in most cases, 6-7 months down the road is going to be a mediation. And if you don't give that above policy demand until the day of the mediation, the carriers won't believe you. They're going into the mediation thinking that you are at the policy or less, and that they can settle that case within policy. Instead, what you want to telegraph, properly so as a plaintiff, is, look, you had $1 million policy. I made $1 million demand. You said no. My new demand is $1.97 million. The only reason I was at $1 million was because that was the policy. But now that you've opened the policy, here's my real value demand. The case is worth way more than $1 million. And now that you've given me the opportunity to open that policy, my new demand is $1.97 million. So now 6 months later, when you're in mediation and you start at 1.97, they believe you because that's been your number for 6 months. And they agreed to mediation when you were at $1.97 million. So you have legitimacy and validity when you legitimately say, I'm not taking $1 million. I'm at 1.97. And even if plaintiffs, you would settle that case within policy, going above the policy well before any mediation allows you to start at 1.97 and the defense goes, we're not paying over the policy, 100 grand. It allows you to go, 1.68 million. Oh, we're not paying over the policy, 200 grand. 1.49. You can make 3, 4, 5 moves above policy. Same case, same facts, same everything. And just because you made an above policy demand right after the open policy, that case settles for $870 rather than $750 because you are able to make. Now, I don't want this to sound like a trick. These are legit. You are telegraphing things that are legit. It will be interpreted properly so by the other side as legit because it is. But the second rule, $1 million policy, did you see I made a $1.97 million demand? And then my next demand mediation may be 1.683. So plaintiff's lawyers, defense lawyers, have plaintiffs you ever received, defense lawyers, have you ever given an offer of $237.59, $230,313.13? You ever wonder why that is? Because psychologically, it conveys that you've analyzed the case, that you're close to your bottom line, that you have considered everything, and this is a really well thought through number. If they just offer you $250, then that is being interpreted as an opening salvo to be negotiable. So if I'm at 197 and I go to 168, I am subliminally telegraphing to the other side, I'm not looking for midpoint. I'm not looking to invite you to go and negotiate somewhere in between. I'm analyzing this case. I know the value. I'm close to my bottom line. That is a psychological thing as well. And so when we make above policy demands, we rarely make a round number demand. Last, this is good stuff, guys. These aren't tricks. People who do this are telegraphing. I know what I'm doing. And because I'm telegraph, I know what I'm doing. It means I know what I'm doing. And that's how you get value in cases. Next, plaintiff's lawyers. If you have a policy limits demand outstanding and there is a deadline coming up, do not answer the phone. Do not respond to emails. Do not take the defense lawyer's call. And I know this because I've got lawyers here in our office that used to be high-end defense lawyers, and they'll laugh every time they hear this. They're like, yep, the carriers told us, hey, man, call the plaintiff and just dig and see if they really, really mean that they're only going to take the policy. And they're skilled at needling you and asking you to try to figure out, right? Hey, I know you're at $1 million and we got a deadline, but you want to mediate? And if you hesitate, if you're like, well, I got to check, you've just telegraphed that you'll take less than the policy. And so this is something you got to understand. So if I answer a phone unwittingly right before a policy, and somebody's like, "Hey, Mike, I know you made the $1 million policy, but would you like to mediate?" I'm like, "I'm happy to mediate after you make a decision whether you're going to open the policy. And if you open the policy, then I'll make a true value demand, and I'm happy to mediate." You gotta know that. Okay, next. And I'm looking at questions just to make sure. Gene, I love the questions, my man. Gene has asked a couple as we go through. How do you answer form rogs pre-lit if you haven't propounded them? Just assume which form rogs are going to ask? Yes, absolutely. Again, stop thinking about how you can't do stuff. Think about how you can. Who cares if it's not perfect form? When they started litigation, then redo it. The point is you're giving them the information. The point is that why by doing it, you're telegraphing what kind of leopard you are. It doesn't have to be perfect. And the other question is, how soon before you make the specific number offer? I don't understand exactly what that means, but if I have a case that is worth a policy or close to it, I'm not going to be giving specific numbers until I've given the other side an opportunity to pay the policy with all the records and everything they need or not. Now, if they choose not to pay the policy, then I'm going to make them pay for it. I'm going to then give my real number value, and I'm going to hold them to it. All right. Now, I just finished talking about we've got info, they've got money. They need info, we've got info. Here are the big ticket items to give back and forth. But for plaintiffs' lawyers in particular, I've also included in this PowerPoint, and if anybody wants it, I don't even know, Beverly Hills may already provide it if anybody wants it. Certainly, if you reach out to me, I don't know if you guys had my cell number, my email, or my social media, you could probably reach me. I'm happy to send it to you. But I list a whole bunch of different ways on this slide and the next one. Going to the scene personally, going to the home of the plaintiff, creating now with Claude Cowork and any of the AI, I mean, you can create timelines and illustrations, PowerPoints for just with nothing. Life care plans, invoke rehab plans, creating a model of the premises with a 3D printer. You ever printed a sidewalk separation with a 3D printer and have a full life sidewalk on a table? I mean, hey, see that? That's a danger. I mean, that blows people away, right? Go to the next slide, please. Freedom of Information Act requests when you've got a governmental entity or if you've got an intersection accident and you want to ask about anything like that. Black box electronic data downloads from cars, canvassing for witnesses and video, making sure that you get the body cam footage from the police, right? There's a whole bunch of things. Go to the next slide. And then lastly for this, before we talk about some things you shouldn't do, there are some things that you can do that will help your case, but will also make the other side have to pull your file and look at it. And you got to think about the fact that just like plaintiffs' lawyers, defense lawyers, adjusters are overworked. They've got more cases and claims than they can look at organizationally. And many times they are looking at the squeaky wheel or the case that is requiring them to focus because a depo's been set, because a motion has been filed, because they just got a bunch of good information and hey, I can probably settle this case and get it off my desk. And so not only as a plaintiff should you be calling your client at least once a month to just check up on them. You got to send supplemental discovery so that the defense has to update that. Very important for sub rosa. Right? You got to, when a defense does an IME, when they send a IME report that you've requested, you got to read the report and make sure that it complies with the requirements of 2034, that there's a diagnosis, a prognosis, a conclusion, that there are the opinions are in there. All of the tests are listed. All the test results are listed. And if that report doesn't comply, it's likely because the defense a defense expert didn't want to put that in writing because the plaintiff has a pretty good case. You got to push for that. Right? Focus groups, we run all the time. But the last thing I wanted to say is, if any of you have your phone, could you pick it up and, well, you mind giving it to me so I could look through your phone? Do you mind? Hell no, you ain't looking through my phone. A forensic inspection request of the defendant's phone will get their attention. Now, the defendant has the right to do it to the plaintiff too. But many times I find that the actual defendant is not really kept abreast of the litigation. And so the carriers may be playing a little bit of games with you, but when they have to ask their client to give them their phone so that the plaintiff's expert can look through it, many times the actual defendant goes, you better settle this damn case. And I get a call, hey, Mike, what can we do to resolve the case? It's just another way of getting this case attention. Let's go to the next slide. And I need Daniel, you got to keep me in line, my man. I'm like cooking with gas, but tell me if I'm going overboard. Okay, I want to talk about, lastly, some mistakes that really can hurt your case. Go to the next slide, please. 1, if you say you're going to do something and you don't do it, you have lost credibility. Ultimatums are great if you follow through. But if you say, I need this discovery by Friday, and if you don't give it to me by Friday, I'm moving to compel with sanctions. If you don't get it by Friday and you don't move to compel, you've lost all credibility. Lepers don't change their spots. You are far better off not giving a deadline or an ultimatum if you're not going to follow it. You're far better off not doing it at all than doing it and not following through. Next. As I've talked about, making a policy limits demand, and if it's not accepted, not going over it. Next. Right. Similar line, if you make a policy limits demand, and then the defense calls you and says, hey, let's leave this 998 open until the day after mediation. If you've agreed to that, you have just telegraphed that you're not really expecting them to pay the 998, to pay the policy. Why would you ever do that? You're telegraphing the wrong thing. Next. Trial dates. I don't know. You can see you can't really see. I got this here. Got this. Those are the trials I have set between now and November. And I won't agree to move any of them. I just got a case yesterday referred to as trials in July. They're like, hey, Mike, if you want to move the trial, the defense would be willing to. I'm like, hell no. We have a very, very hard rule that we will only move trial dates for the health or family of the defense lawyer. If, in fact, the defense lawyer says, I can't do the trial, I got to move it because I'm having surgery, my family's got a family trip, something like that, no problem. But no other reason. No other reason. Mike, we don't have the time for, we got too many depots, we got to take experts. We'll get it done. Oh, Mike, if we could move this trial, we could get together and mediate and settle the case. Nope. Right? We fight every motion to continue trial. Whether we're going to win it or lose it, we at least go on the record, go down swinging, putting on the record, Judge, please note that this will be the last continuance. I've had 11 trials come up in the last 5 weeks. All 11, the defense made a motion to continue trial. All 11 of them. The judge denied 5 of the 11. All 5 settled. The other 6 have not settled. Trial dates make the world go around. I had a trial on next Monday, just settled yesterday. That defendant made 2 motions to continue. Judge denied them both. Case settles. Trial dates make the world go around. Next. Arbitration dates too. Arbitration dates too. Another big deal is if you get discovery plaintiffs of any type, even with a general attorney-client work product doctrine objection, you got to demand a privilege log. I have found, especially, with big corporate defendants, their interpretation of what is attorney-client and work product is so broad that it basically excludes everything. By holding the feet to their feet to the fire, where they have to show on a privilege log who looked at the document and why it is privileged. One, I have found wholesale sets of documents suddenly were erroneously marked as attorney-client that, oh, Mike, you're right. Now that we think about it, oh my God. But also, the privilege log has to be in a situation where it is enough information that you can question whether it is covered or not. And as a plaintiff, I try not to object as much as possible. I want the other side. Look, you got to have the information. Get over this fear. Well, I got to prophylactically say every objection under the sun because the 0.1% of the time that it goes to trial, I might get screwed. And you waste time. We don't even ask special interrogatories anymore. 9 months of meet and confer, you get a watered down BS objection-filled answer that doesn't get you anything. Why? You want my information? I got it? You got it. No objections. Oh, 1 time out of 500, I'm going to go to trial and kick your ass with that one missed objection. Doesn't really happen. But what does happen is I've just communicated, you need the information, you got it. I'm transparent, you got it. By the way, I'm the kind of lawyer that knows what objections mean. I'm the kind of lawyer that has been in trial enough to know whether it matters or not. I'm the kind of lawyer that knows what you need, and I'm not here to get in the way because I'm going to win on the facts and the evidence. And people pay attention to that. Next. So I am going to end, and then we'll take some questions. This is gold-plated stuff, but it's not super complicated stuff. It is basic understanding. So here's my information. If you guys want to take a picture of that, if you go to the next slide, I think I've, this is what I just did last month. Sorry, we just had a great Alder Talk Summit where our second annual is next January at the Ritz-Carlton Bacara in Santa Barbara. We'll have a bunch of information on that. But, I've talked about a lot of law stuff, but I also talk a lot of life. We talk about networking, about using AI, about social media marketing, about goal setting, about taking care of your mind and your body so that you're not physically and mentally exhausted all the time. How to be a better lawyer requires you to be a better person and a better physical and mental person. And then lastly, if you scan this, it has access to my resources, which you can order my Trial Lawyer's Bible, my phone number, email. You know what? I'm going to look. Let me see. Anybody texted me yet? Let me just see. One, John Terry, bravo. Somebody from Tone Beck. Come on, man. I got you, Josh. So look, I got 87 people on here. 2 people texted me. Now, I'm not being critical. That's expected. What a gift it is that most people don't pull the trigger, that most people hesitate. When I give speeches, I talk to I'm an adjunct professor at Loyola, and I talk to people at law students that come to learn, to get information. All right, come on, Howard, let's go. Gene, let's go. And I say, look, you don't have to compete with 85, 87 people. You probably have to compete with about 8. Because maybe 10% consistently follow up, step outside their comfort zone, write me a personal note. Thank you, Mike, for this presentation. Hey, you told me to follow up. Can I get your book? Can I come over to your office and see how you're set up? Mike, you offered help and advice on how to run a profitable firm, how to network, how to learn social media and AI. And I took you up on it by following up. Only about 10%, maybe even less, will do that on a regular, consistent basis. Those are the people that 5, 10 years from now, you'll be looking at as the ballers, the people giving speeches, etc. Not because they're super geniuses and you're not because they're so much better looking or a better orator or have more money or whatever. I mean, all that stuff helps. It helps that I'm an excellent dancer. But what's important to my success is that I have figured out a routine of consistently stepping outside my comfort zone and certain things that I do day in and day out, learning, building my body, building my mind, writing personal notes, commenting on social media, eating right, exercising, that build upon those things. Is it hard? Yes. Is it being hard a gift? Yes. Because that ability to consistently do stuff that you don't feel like doing is what will set the 8 out of the 83 of you apart. It is 100% correct. Now, I am getting tons of texts. I love it. Bravo. Every one of you will get a response from me. Just like I was taking photos of the participants, because I want to follow up and thank you for taking the time to listen to me, to thank you for having the initiative to get on this in the middle of the day on a Friday. I know that leopards don't change their spots too. And I know that people that follow up, that come and listen in the middle of a weekday when they could be doing other things, those people's leopard spot also means they're likely to be successful. They're likely to be the kind of people I want to hang out with. They're likely to be people that I want to hire, that I want to work with, that are probably people that are similarly aligned with my values. And I've learned that without ever meeting you because of the text or the no text, because we all make impressions. You don't think jurors do that in 1 second? You don't think you do that with everybody when you're in the mall and you're looking at people? All the time. So let's finish with talking about some questions. Somebody asked what provider to scour your clients. It's called footprint.com. Gene, you said Chris Voss suggests you do round numbers for the first several offers and then a true value. Exactly. So what he's talking about is if I'm at the beginning of a a mediation. And by the way, I went to the Mark Lanier's settlement negotiation academy. I don't know if I have time for this, but Daniel, this is dynamite. Anybody wants to follow up on this is great. There's two types of offers and demands, right? Competitive and cooperative. Competitive is like if you got a case that you want to settle for $1 million, your opening demand is like $9 million. A competitive, if you want to settle for $1 million, is like 3, right? And if a defense is responding and they've got $1 million to settle the case, a competitive offer is like 50 grand, but a cooperative one is 250. And generally, the way that negotiations work and what Gene was talking about is that the opening demand is usually a round number. It is usually not super competitive, but it's somewhere pretty high. And you now invite the defense to decide if they want to fight competitively or if they want to be cooperative. And a round number at the beginning, $9 million, rather than 8, 9, 7, you don't want to early on big money convey that you're already at your bottom line. If in fact you'd settle the case for $2 million, you don't want to say 9, you don't want to say 8.97 because you look like a fool going down. But if you say a round number, you're inviting the other side to similarly give you a round number. And then once you get closer, then maybe you can change the number. But the most successful negotiation strategy that's been studied is that if the plaintiff is competitive, then the defense is going to be competitive. If the defense is competitive, the plaintiff becomes competitive. But once both sides start being cooperative and they both feel generally that the number where they're at is a reasonable number, then 99%, as soon as both sides get to that point, 99 times out of 100, the case settles in the midpoint. And so the point is when you're negotiating, as a plaintiff, you don't have to be a hard ass all the time. You only have to be a hard ass if the defense is a hard ass. But you always want to telegraph that if the defense is not going to be a hard ass and they're going to be cooperative, I will be cooperative too. Because I just want to get us to a point where both sides think we're being reasonable. And then likely the case settles. Anyway, I'm happy to talk about that more. There's a lot of great stuff. I read a bunch of books on that. It's great. Okay. Next, do you have a preference in terms of who makes the first move? Yes. I used to think he who speaks first loses. That has been completely debunked. Plaintiff has to make the first move. What the plaintiff's first demand does has more of an effect on the overall value. And you always want to try to set the tone. I get that you are afraid that you're not reading it right. You got to pull the trigger, right? It's very important for the plaintiff now, and I've learned this, to make an initial demand. You can't wait for the other side. I mean, once in a blue moon, you're like, oh my God, they just offered me more money than I thought the case was worth. But that very rarely happens. And again, you got to make a decision. What statistically the best negotiation is, especially if you're at a mediation, is the plaintiff's demand is not uber competitive, but it's not super cooperative. You're kind of in the middle, and you kind of see now if the defense comes back with a reasonable cooperative number, then you've got to respond reasonably and move. But if the defense comes back with a very difficult competitive number, then I'm going to stay competitive until you become cooperative. But once you become cooperative, I'm going to respond in kind. That is statistically the most effective way to resolve cases. Next, I heard a judge in Van Nuys Superior say that state court, there's no requirement for a privilege. They shouldn't be a judge. That's not true. Statutory authority to compel a privilege law. Yes. I mean, I can look it up in the Code of Civil Procedure. I don't know which offhand, but hell yeah. By the way, if you had my cell number or my email or my social media and DM'd me and you followed up, I could probably show it to you right away. But also, I can show you our demands for privilege logs all the time. Seth, please tell me your phone number again. 310-710-3345. Perhaps the smartest person in the room, Don Cape. I just learned more in an hour than in a year at ADR. I could not agree more, Don. I have been telling people all my life, not only how fun I am, but how smart I am. And you are the first person to actually approve that. Thank you very much. Boom. Last question, it looks like. Ani, is it a good idea to send a 998 demand in every single case? By the way, at the back of my Trial Lawyer's Bible, second edition, I have listed a lot of our internal litigation strategies. Why am I giving them away? Why could the defense read them and use it against me? It's because I know that 9 out of 10 defense lawyers are not going to use it against me. They're going to actually look at it and go, dude, this guy knows what he's doing. I don't want to mess with him. And he's giving me all the information I need to look good for my carrier to pay him money. Just pay him some goddamn money. You know who benefits the most from that? My clients. Oh my God, you mean, Mike, you're a client-centered lawyer? You mean you believe in fiduciary duties and your oath to your clients? You mean, Mike, you believe that you have an obligation to move the case forward as fast as possible to get your clients money as fast as possible? Hell yeah. But you know what the silver lining is? Happy clients refer you more work. Happy clients make you happy. Good karma is good karma, but it's also a good life. And it also draws good people to you. And it also exposes the leopards that are not. Ani, the question was, do you usually make it by 998? And one of the policies that we have is you got to understand what a 998 is. A 998 demand at trial, you have to beat that number for the plaintiff. Okay. But that means there's a judgment by the person who made the 998 against the person on the verdict form that the 998 was made against. So there's got to be a judgment, this plaintiff versus this defendant. So that's a problem if you have a defendant, which is the driver and the company. If you make a 998 against the driver, and then you learn later that the company takes over course and scope, and you dismiss the driver, and you get a verdict against the company, the 998 is not effective because it wasn't made against the company. Similarly, if you have more than one plaintiff or more than one defendant, and you make a 998 on behalf of 3 plaintiffs who are in the car for the $1 million policy, there's not going to be a judgment of one plaintiff versus one defendant. So you can't really make a 998. You got to make just a general demand for the policy. But having said that, all things being equal, if we can make a demand by 998 that would be effective, we do it. If we can make it by 998 rather than a letter demand, we do it. Not only because of the benefits of a 998, but when we send the 998, and it's a 30-day window, we also send an email that says, by the way, you got 30 days. If you're saying you need more information, don't wait 30 days. Ask me today. By the way, my plaintiff is available for depot tomorrow, IME tomorrow, and any day in the next 30 days. So when 30 days from now you tell me you haven't had enough time to do anything, I'm going to ask you, and the court will ask you, well, why haven't you done something for the last 30 days? You're thinking. The silver lining is lawyers who know that, who do that, the carriers recognize that, and they're more likely to pay the 998 because they know that leopard who knows how to preface the 998 also likely tries cases, spends money, gives seminars to the Beverly Hills Bar, is an excellent dancer, clearly funny. They know all of that by that email offering the plaintiff for depo. It's really important. How we doing? Oh, we got more. Hey, should I answer these questions? I got a little time. I don't know if...
Yes, of course, we can answer those questions.
Okay. Yeah. Any suggestions on how to break an impasse with defense counsel who just won't negotiate? Well, one, if you got a trial date that got set out to 2029, make a 998. At least have the clock running, right? If a defense lawyer, because of likely not malintent, but just because they're busy, they won't take the plaintiff's depo. I have noticed my own client's depo. The defense lawyer angrily, Mike, you are not allowed to take the plaintiff's depo. I'm like, well, I'm going to do it. Shockingly, they notice the plaintiff's depo for the same day and the depo happens. If they're at an impasse, let me send you my notice of inspection of forensic examination of the defendant's phone. Gets their attention, right? There's some other stuff. If you want to call me, boy, I wish you had my cell number. You could call me or text me. I've got a lot of other ideas. David Olson, come on, man. Privilege log requirement, CCP 2031.240. I'm going to start a little. CCP 2031.240. Come on, man. I mean, whatever it is, remember that shit. By the way, if you can spell cases, like in the depo case, if you can spell cases, you scare the other side. I have a whole thing on taking depositions. And you know that in a depo, a lawyer can't instruct a witness not to answer unless it calls for privacy or privilege. There's no other reason that they're allowed to do that. By the way, the case is Stewart versus Colonial Western, STEWART. By the way, privilege log requirement is CCP 2031.240. Just that is so persuasive to the other side, to judges, you just wouldn't even, I'm like, but I mean, all you're showing is you know how to spell, that you can remember numbers, but it's far more than that, because people who do that also statistically try cases, spend money, good lawyers, fight motions to compel, take depositions, all of that. Okay, Alexander, I do employment work as well. How often do you make 998s in employment cases? And what's the strategic use of them as opposed to PI, given that employment cases have attorney's fees awarded statutorily? Exactly. I mean, it's a very good point. 998s are not nearly as a big deal, especially because employment cases are not necessarily super expert dependent. They're less important in employment cases. PI cases, I think they're very important. Employment cases are 998s are important when defendants make 998s in employment cases. That becomes much more important. All right. Any other questions? Please feel free to reach out. I hope this was helpful. I do appreciate everybody logging on. And Daniel, I don't know if you keep a record of who showed up, but I would love to have a list of that so I could thank people. But if anybody needs anything, please reach out. If you want to come anytime, feel free. I'm an open book. Come over to the office. Check out my huge studio, social media studio. Happy to show you how to run your firm with projections and case grades, how we use dashboards, how we use our case management software. In fact, I've got somebody coming over who's got a solo firm this afternoon. I'm going to go through how to grade cases, project cases, how to project value over to the next year, how to move cases along to gauge your cash flow. That's going to help him figure out if he can get an office, hire somebody new, how much money to spend on advertising. There's a lot of stuff that goes into this. It's a constant learning process. I believe strongly of all boats can rise, and I'm happy to help. You just got to reach out, and that's it. Thank you guys very much.